An estate planning system makes sure your plan does what you expect it to do, not what you think it does. If you search on the internet for how to create an estate plan or the steps to estate planning, you'll find that the articles talk about creating the documents, not the process leading up to the documents. This is literally putting the cart ahead of the horse. There are several steps you need to go through before creating and signing the documents. Let's talk about the 7-step planning system. Step 1 is to decide to take action. It's better to get started than to let this sit as something to get done later. You can make changes and fine-tune the plan in the future. If something were to happen today, an auto accident, household mishap, or medical incident, and leave you unable to make decisions, your family will pay the price and face the problems. Commit to creating your estate plan just as soon as possible, or your family may pay a high price financially and emotionally. If you don't act, state law will decide who makes decisions if you can't make them yourself. State law will decide who gets your estate, how much, when, and how. The second step is to pick your estate planning goals. Different people have different goals. Some want to leave as much as possible to their children. It's up to you to decide what your goals are. You may have multiple goals, and that's fine. Some of the most common goals are to avoid probate, protect assets and family, maximize inheritance, prepare for long-term care, and care for children with special needs. Next, you need to decide who will make your decisions if you can't. You need to pick somebody you know and trust to manage for you when you can't manage for yourself. This happens in 2 cases. First is when you're unable to make decisions because you've had an accident, medical incident, or other mishap that leaves you unable to make decisions. It's extremely important that you have somebody picked ahead of time to make your decisions. If you don't, then your family will be forced to court to get a judge to pick somebody to make the decisions for you. You can plan on that trip to court costing about $3,500, or you can create a comprehensive plan to avoid court for about $675. Second is when you're gone. You need to pick somebody you know, like, and trust to manage and distribute your property. Next, you need to take at least a basic inventory. It's very important that the loved ones you leave behind know what you had and what you owe. They will have to deal with both parts of it. Part of settling an estate is paying off debts, and the other part is distributing assets. And when you do your inventory, don't forget to include intangible assets. If you have a patent, book rights, and other things, those need to be included. Step 5 is deciding who gets what, when, how, and how much. You get to decide who gets what, when, how, and how much instead of the state. If you don't have a plan, then state law decides for you. It's not uncommon for me to tell stepchildren that they get nothing because mom or dad didn't have a plan. By default, the state's plan is only for blood relatives or adopted children to inherit. Then, you decide how you want to avoid probate. You can decide to have nothing left. However, this is very difficult to do. But it is easy to have nothing left in your name. More on that in just a moment. The first plan we can do in Arkansas is called a beneficiary plan. This plan depends on a beneficiary designation for your real estate and beneficiary designations for the rest of your property. For many people, it's the plan for them. It's fairly simple to implement and maintain. This plan also includes a will for a safety net. If you have family with special needs, young children, children with addictions, children with marital issues, or complex distribution rules, then you need a trust. We probably write 25% trust and 75% beneficiary plans. When you give money, real estate, or other property to your trust, you are literally taking that property out of your name and putting it in the name of the trust. You are literally giving your property to the trust. Therefore, you don't have anything left in your name. When you pass, there's nothing to give, or nothing left in your name. The person you name takes over managing the assets in the trust and follows the instructions. Finally, the last step is to create the documents. The last step is creating and signing the documents that cover the decisions you made in the previous 6 steps. Those documents may include your will and/or trust, Durable powers of attorney for finances, legal matters, personal matters, and health care. A HIPAA waiver which tells the doctors and nurses who they can talk to, and a living will which tells the doctors that if you are in a vegetative state, coma, or otherwise won't recover, do you want machines to prolong your life or not? I'm Gary, the founder of DeWitt Law. Set up a time to talk about the benefits of estate planning. Go to DeWitt.law or call 479-717-6300. Get peace of mind. Protect yourself, your family, and your money. Call 479-717-6300 or go to DeWitt.law.